The next case I would like to consider is the Kosmar Villa Holidays case, where the judgment of the Court of Appeal was delivered on the 29th of February last year. Now, this is an important case for contract lawyers and insurance contract lawyers because it considers the doctrine of election in the context of breaches of claims conditions. In this case, there was a clear breach of a condition precedent in Kosmar Villa Holidays' liability policy because they did not notify an occurrence promptly. They had left it a year before they notified their insurers that one of their holiday customers, an unfortunate Mr. Evans, had had a serious accident at one of their villas in August 2002. In the weeks following the late notification of the occurrence in September 2003, the insurers did not deny coverage relying on a breach of condition precedent, nor did they expressly reserve their rights. Instead, they asked a number of questions which suggested that the occurrence would be covered by the policy. By late October 2003, having taken legal advice, insurers repudiated liability relying on the breach of the condition precedent. The commercial court held that the insurers had elected not to rely on the breach of condition precedent by reason of their failure to take the point immediately after the late notification and by taking steps towards the defence of the occurrence. So the commercial court held that it was too late for insurers to repudiate liability in late October 2003 and they had lost their right to rely on the failure to comply with the notice condition precedent. The Court of Appeal, in an important judgment by Lord Justice Ricks, reversed the decision, and in essence the Court of Appeal has held that there is no scope for the application of the doctrine of waiver by election where an insurer is presented with a non-compliance by his insured with a condition precedent. Unless the insured can actually make out some form of estoppel, there is no scope for loss of the right by application of the doctrine of waiver by election. So unless an insured could show that he had relied to his detriment on a clear representation that the insurance would respond, made after the insurer has become aware of the non-compliance, the insurer is entitled to take the point subsequently, and there's no set time limit within which he has to make his election. Now, my own view is that this is actually quite an important pro-insurer case. It is notoriously difficult to establish an estoppel. So although an insurer is obviously well advised to reserve his rights at the earliest opportunity, a failure to do so will not debar insurers from subsequently relying on a failure to comply with the condition precedent.